Hello and welcome. My name is Ilda and I'm a partner in the Immigration Department at Kingsley Napley. Given that the transition period will end on 31 December 2020, it will mean that from the 1st of January 2021, freedom of movement will end for European citizens wishing to travel to the UK. They will then be subject to our immigration rules in the same way as non-European citizens, with the exception of Irish citizens who will continue to have the full right to work and live in the UK, much like British citizens will have the same rights in the Republic of Ireland. During today's presentation, we'll be looking at what this means for lawyers based abroad and travelling on non-British or Irish passports in order to see their clients here on a fly-in, fly-out basis. My first intention is to ask my colleague Jessica Clay, a senior associate in our regulatory department, 3 questions that we think you should be aware of as law firms based abroad looking to send lawyers here on a fly-in, fly-out basis. Thereafter, Jessica will ask me a series of questions that, again, we think you should be thinking of from an immigration perspective. To that end, the first question that I have to ask is, Jessica, what is the regulatory position for European solicitors wishing to fly in, fly out, FIFO, out of the UK post the 1st of January 2021?
Thanks, Ilda. Well, the rights of EU lawyers in the UK are set out in the withdrawal agreement. And it's worth noting that there are separate agreements for Swiss lawyers on the basis of the Swiss Citizens' Rights Agreement, and also for the 3 EEA EFTA states, which are Norway, Iceland and Liechtenstein, under the UK EEA EFTA separation agreement. So from the 1st of January 2021, if the UK and EU do not sign a free trade agreement covering legal services, UK lawyers will be subject to the same requirements and limitations as lawyers from third countries. So in short, this means they will be able to continue advising under their home state professional title on any aspect of English law in England and Wales, as long as it is not a reserved legal activity. And I will talk more about this later. Additionally, EU lawyers can advise in England and Wales on the law of their home country, international law and EU law, including on a FIFO basis, but again, providing this is not in relation to a reserved legal activity. I would also add that the UK is known to be an open jurisdiction for foreign lawyers, and importantly, the freedom for lawyers qualified in foreign jurisdictions seeking to provide legal services in the UK will not change after the end of the Brexit transition period, and this is irrespective of whether the UK and EU reach an agreement on future relationships.
Thank you, Jessica. Are there any conditions or restrictions attached to the scope of permitted practice?
Well, barring the 6 legal activities which are reserved to the legal professions of England and Wales, which are known in the Legal Services Act 2007 as the reserved legal activities, the position is that you do not need to be a qualified lawyer to provide legal services and or draft contracts under English law, and this includes the provision of general legal advice. As a foreign lawyer, you can also represent parties in arbitration or other forms of alternative dispute resolution. As with many jurisdictions around the world, certain types of legal work in England and Wales are actually reserved to lawyers of England and Wales. And these are as follows: the exercise of a right of audience, the conduct of litigation, reserved instrument activities, which are things such as real estate transactions, probate activities, notarial activities, and the administration of oaths. And I should also mention that under the Immigration and Asylum Act 1999, only foreign lawyers who are partners or employees of UK solicitors can provide immigration advice and services.
Thank you. Will legal professional privilege, LPP, apply?
Well, all UK jurisdictions recognise that when practising in the UK, legal advice provided by all qualified foreign lawyers who are accredited by their local bar is covered by legal professional privilege. The position will therefore not change in respect of EU lawyers. LPP may apply whether the foreign lawyer is advising on local law or the law of their qualification, so long as there's a lawyer-client relationship and other requirements for privilege are satisfied, and this is well supported by established case law.
Thank you.
Ilda, I'd quite like to ask you some questions now. So first of all, do you have any top tips for overseas-based law firms that need to send their lawyers on non-British or Irish passports to the UK in order to see their clients here on a fly-in, fly-out basis?
Thank you, Jessica. I've got a few tips. Firstly, as a result of COVID, lawyers travelling to the UK should always firstly familiarise themselves on the latest rules as to whether or not they're required to self-isolate on entry or perhaps fall within an exemption. These rules can change at a moment's notice, so it's important to check in advance. Secondly, please always check whether you have the appropriate travel insurance, including health cover, especially as of the 1st of January. Then thirdly, law firms should be, along with the foreign lawyers based abroad, should check whether the activities that they intend to perform in the UK can be done as a visitor in advance of travel. We've just had a new immigration system that was introduced as of the 1st of December that covers non-European citizens, and these same rules will now apply to European citizens as of the 1st of January 2021, unless they've got a right to reside in the UK already. For example, if you have a European citizen who was here pre the end of the transition period and they've acquired settled status, this will give them the right to live and work in the UK on an indefinite period. It's also worth pointing out that EU, EEA and Swiss citizens will not be able to use their national ID cards to travel to the UK from 1 October unless they hold either settled or pre-settled status under the European Settlement Scheme. This is basically designed for EU citizens that arrived in the UK before the end of the transition period, or they have what we call an EU Settlement Scheme family permit, or a frontier worker permit because they were working in the UK but not living here before the end of the transition, or a Swiss service provider visa. In these cases, they'll be able to enter the UK using their national ID card until at least the 31st of December 2025. Now, what does that mean for non-EU citizens? Well, they're not affected by Brexit. So lawyers travelling on non-British or Irish passports will always firstly need to check whether they are required to obtain a visa in advance of travel, even if it is just for a business meeting. Now that's very typical, for example, Indian citizens, where they always are required to apply for a visa in advance of travel, regardless of purpose. Then there are citizens that don't need to necessarily apply for a visa in advance of travel, so they can come visa-free. So citizens from the US, Australia, Canada, Japan, Singapore, South Korea, and New Zealand can, for example, continue to make use of our e-gate system, as well as EU, EEA, and Swiss citizens, even after the transition period ends. Now, what does that mean? Effectively, if you're making use of our e-gate system at our borders, you are effectively granted a visitor visa for 6 months, but this leave does lapse if you leave the UK at the end of your visit. So essentially, it's a single entry visa. Now, it doesn't permit employment. What it does, it allows you to carry out certain business visit activities that I will outline later on. Now, for non-European citizens that are required to obtain a visit visa in advance of travels, for example, Indian citizens, they can apply for a standard visitor visa. It could be a 6-month visitor visa. It could be one that lasts for a 2-year, 5-year, or 10 years if they need to meet or visit the UK regularly over a longer period. But you can only stay for a maximum of 6 months on each visit.
Thanks, Ilda. That's really, really helpful. My second question, what are the general business visit activities that can be performed?
Thank you. So I know we're now talking exclusively about lawyers flying in on a FIFO basis, but I did think it was just worth pointing out what are the general visitor activities that business visitors can perform when in the UK. So generally, a visitor can attend business meetings, conferences, seminars, interviews. They can attend one-off talks or give a one-off talk, a series of talks and speeches, provided they're not organised as a commercial event and will not make a profit for the organiser. They can come and negotiate, sign deals and contracts, attend trade fairs for promotional work, carry out any form of site visits, so that could be for multinational law firms, gather information for their employer overseas, or be briefed on the requirements of a UK-based customer, provided any work that is done for the customer is done outside of the UK. Now, for multinational law firms that have offices scattered across the world and an office in the UK, the rules also allow for employees of overseas-based companies to come to the UK to advise and consult, troubleshoot, provide training, or share skills and knowledge on a specific internal project with UK employees of the same corporate group, provided no work is directly carried out with the clients. Now, as far as our immigration rules and lawyers are concerned, an overseas lawyer is able to come to the UK and advise a UK-based client on specific international litigation and or international transactions. Now, that doesn't mean it should stop a lawyer practicing in any other field coming over to advise clients during a meeting on a FIFO basis. Now, the thing that is really important is that the general rule is that visitors shouldn't normally receive direct compensation from a UK source, although it is possible to bill a UK client for a lawyer's time in the UK on a FIFO basis, where the lawyer's overseas employer is contracted to provide services to a UK company, and the majority of that contract work is going to be carried out overseas.
Thanks, Ilda. What's the position for lawyers coming to provide advocacy for a court or tribunal hearing?
Now, this does happen quite frequently. So our immigration rules have a specific subsection under our visitor rules that allow for what we call certain permitted paid engagements. In this case, a qualified lawyer coming to provide advocacy for a court or tribunal hearing, arbitration, or other form of dispute resolution for legal proceedings within the UK where they've been invited by the client is permitted under the category. Now, what this means for the lawyer is that they will be permitted to come to the UK and stay here for a period of up to 30 days. Now, in practice, if you are able to travel visa free, so in other words, you don't need to get a visa in advance of your travel if you are a non-EU citizen, lawyers can travel into the UK. For example, if you're a US citizen, use our e-gates. What you can do is have the invitation letter and present yourself to a border officer who can then stamp you in under the permitted paid engagement. If you are required as a non-European national to obtain a visa in advance of your travel, you can produce the invitation letter that you have received from the client and apply for your visa at the respective British Embassy in advance of travel. Now, this permitted paid activity will also apply to European Economic Area nationals, European citizens and Swiss citizens from next year.
Great, thanks, Ilda. What happens if the lawyer regularly needs to travel, say every other week to the UK in order to see the client? Do you think that will be a problem?
This is really interesting because in our immigration rules, we haven't got a specified maximum period that you can spend in the UK in any period. So in other words, there isn't a, you must spend no more than 6 months in a 12-month period. However, looking at the modernised guidance published by the Home Office, UK Visas in Immigration, effectively, any visit should not exceed a maximum period of 6 months. And it's also clear that any applicant's travel history, that they're not seeking themselves or seeking to stay here for extended periods that look as if they're trying to base themselves in the UK. Because if that happens, you can find that you might be stopped by a border officer who's going to determine whether or not you've perhaps moved your home. And if you are a frequent traveller, it's probably best to have a support letter from your law firm, just explaining that essentially you are an employee of an overseas law firm, the purpose of your trip, and that you're not really basing yourself here. You have every intention of leaving the UK, and just explaining the reason why there is such frequency.
Thanks, that's really helpful. If a work permit is required, how quickly can it be obtained? And is it something that might be applied for in advance of travel, do you think?
So I think generally the activities that I've just described, and assuming lawyers are coming in on a FIFO basis, I don't think that a work permit is necessarily required. However, if it were to go beyond the scope of a standard business visitor activity, for example, with a multinational law firm where there's a requirement for an overseas-based lawyer to come to the UK to backfill a job in the UK office of a multinational firm. So maybe someone's gone, a lawyer in the UK has gone on maternity or paternity leave, then work permission would be required. And in that instance, the best visa categories would be to obtain either a skilled worker visa or an intra-company work visa in order to actually continue the work that the UK office requires. Under our current rules, work permission has to be applied in advance of travel, and generally at the moment is currently taking anything from 5 to 15 working days in order to secure a visa, and that is actually from the date of the visa appointment.
And my final question, what can you do if all else fails?
So for now, I think, Jessica, the good news is that European citizens, EEA and Swiss citizens can continue to make use of our e-gate system. So it should be allow them to travel to the UK quickly if it means on a moment's notice. If for whatever reason they can't come to the UK, my advice is always try and conduct any client meetings using perhaps Zoom or any other form of electronic medium so that they can continue to achieve the goal that they've set out to achieve, but in a way that where technology allows us to perform our role and use it in the best way we know how.
Many thanks, Ilda.
I'd like to thank my colleague Jessica Clay for sharing her expertise with us today, just because it is a very important topic, considering where we are with the Brexit negotiations. And I'd also like to thank all of you for listening. We hope that you found this really helpful, and let's see what's going to happen with the negotiations going forward. Thank you.